dispute resolution processes 争议解决方法 When a dispute arises between the contracting parties of a sales contract, there are a number of processes that are available for the resolution of the disputes. In this section, I will discuss some of the processes, and in particular, I will talk about arbitration and compare it to litigation, 诉讼. The first resolution process is negotiation, 友好协商. In a negotiation, both parties attempt to reach agreement or settlement of disputes through a give and take in informal discussion. No third party is involved in negotiation. The process is informal and amicable and often results in creative solutions, longer-lasting outcomes, greater satisfaction, and improved relationships. If the dispute cannot be settled between the two parties, a neutral third party may be requested to step in to help. Conciliation, 调解, is a such process. In the process of conciliation, the concerned parties seek to reach an amicable dispute settlement with the assistance of the conciliator, 调解人, who acts as a neutral third party. The conciliator, upon the request of the parties, to provide them with a non-binding settlement proposal. Conciliation is a voluntary and flexible process. Conciliation has no legal standing, and the conciliator usually has no authority to seek evidence or call witnesses, usually writes no decision and makes no award. Therefore, the parties may want to resort to a more formal way of dispute resolution, that is arbitration, 仲裁. Arbitration is a technique for the resolution of disputes outside the courts. The parties to a dispute refer it to arbitration by the third party, the arbitrators, or arbitral tribunal, 仲裁员或仲裁庭, and agree to be bound by the arbitration decision, the award, 仲裁裁决. A third party reviews the evidence in the case and imposes a decision that is legally binding on both sides and enforceable in the courts. The binding decision of arbitration means that the contracting parties must accept the arbitrator's decision and cannot try to resolve the same dispute in court. Litigation is the ultimate legal method for settling disputes between the contracting parties. In the litigation process, a case called suit or lawsuit is brought before a court of law suitably empowered, having the jurisdiction to hear the case by the parties involved, the litigants, for resolution, the judgment. The court decision is legally binding. Arbitration has several advantages over litigation. Arbitration is faster than litigation in court. Once arbitrators are selected, the case can be heard immediately. In a civil litigation, on the other hand, a case must wait until the court has time to hear it. It can mean many months, even years before the case is heard. 与诉讼相比，仲裁所需的时间较短。Arbitration is more flexible than litigation. For instance,
The arbitration process can be customized to meet both parties' needs by choosing suitable arbitrators. This is especially useful when the subject matter of the dispute is highly technical. Arbitrators with an appropriate degree of expertise can be chosen. But in litigation, one cannot choose the judge. 仲裁比诉讼的灵活性更强。Confidentiality. Arbitral proceedings and arbitral awards are generally non-public and can be made confidential, while litigation is a formal process conducted in a public courtroom, which may lead to bad publicity of the concerned parties. 仲裁的过程和结果是保密的，而诉讼的过程和结果可能会被公开。